Well, good afternoon, everybody. We're going to give it a second or two for everyone to load up on this Zoom call. Happy afternoon to all, and thank you for joining us this afternoon for a special education session on arbitration. I want to introduce myself. I'm Scott Zucker. I'm this year's chair of the dispute resolution section of the State Bar of Georgia. It's been a really great year so far in our section. And as you know, we've had a lot of programs and activities in our section and want to continue to invite you to be involved in the dispute resolution section if you're not already, and join us as a member and continue to participate in the programs that we have through the rest of the year through 2024. Again, today we have a unique program. We've done a lot on mediation over the last few months, and we really wanted to turn to our attention to arbitration. And who else better than to train us in the world of arbitration are the folks from the American Arbitration Association. So I'm really excited to have with us today two folks from the AAA. And let me introduce them now, and then I'll turn the program over to them. First, we have Iman Hyderlez, is the Regional Vice President for the Construction Division covering the Southeast and Midwest regions. Iman joined the American Arbitration Association in 2017 as a director of ADR services for the AAA's commercial division. Iman is primarily responsible for administrating large, complex cases, panel recruitment, outreach, and education initiatives, both internally and externally at the AAA. Iman, thank you for being here. It's so nice to work with you on this program.
Thank you for having me.
And next, along with her, we have John Bishop. John is the Vice President for the AAA's Southeast Case Management Center in Atlanta. In this role, he's responsible for the case management operations for the AAA's commercial and construction divisions in the Eastern United States. He's also responsible for business development and the AAA's roster of arbitrators and mediators for the AAA's commercial division in Georgia and Alabama. So, John, thank you for taking the time to be here as well to have us learn from both of you.
Thank you. Appreciate it.
So I'm going to turn it over to the two of you, and folks, if you have questions, please put them in the chat, and Iman and John might answer them during the session, or we'll close with a Q&A session as well. So please put your questions in the chat. Make sure we get them answered. Thanks, everybody.
Thank you. So, John, let me get the slides up and we can get started. Are you able to see them?
Yep, I've got them.
All right, fantastic. I'm ready when you are.
All right, if you want to go ahead and advance then. So good afternoon, everyone. We thought a good topic to talk about today would be disclosures and ethics, something that AAA is quite, I want to say, fanatical about. It is something that usually comes up in just about every presentation that we give because it is something that we consider to be so serious. So a best place to start when you're talking about disclosures and ethics, of course, is the Code of Ethics for Arbitrators in Commercial Arbitrations. This is a great document that I would encourage everyone to become familiar with. Really sets forth all of the expectations that any arbitrator should follow, whether you are working independently or with any sort of arbitral institution. So we'll go through some of the highlights. Canon 1, an arbitrator should uphold the integrity and fairness of the arbitration process. I think what's key about this canon is it's so much broader than just your service on an individual case. This canon really imposes a lot of obligations on a broader scale. You have to keep in mind that as an arbitrator, you're not just working on the case that you've been assigned or that you've agreed to serve on. You really are representing the arbitration process as a whole. For many users, this might be their first experience in arbitration, and the performance that you give really will set the stage for whether or not that person might ever come back to arbitration or not. I often joke with my colleagues that ADR really isn't alternative anymore. I think we have been successful over the last 100 years or so in getting dispute resolution as part of the mainstream when it comes to dispute resolution. But there are still a lot of people out there who haven't had the chance to experience it yet. So when you are serving as an arbitrator, keep that in mind. You really are more than just an arbitrator. You are an ambassador for dispute resolution as a whole. So looking at Canon 1 then specifically towards a case, it's imposing some obligations on you in terms of what you need to do, how you need to approach that case. Some of the keys that are set forth in Canon 1B, they require an arbitrator to be impartial, independent, competent, and available. So I think when we think about impartiality, everybody thinks about disclosures that you have to make. You think about those relationships that you might have with attorneys or parties or your colleagues in the legal or business industry. But impartial is so much more than that. Impartial really also is about how you're carrying yourself, how you're presenting yourself in an arbitration. It can be something as simple as referring to an attorney who you've known for 20 years by their first name and talking to opposing counsel by their last name, because you're not familiar with opposing counsel. Might be the first time that you've ever interacted with them. Every interaction you have as an arbitrator, you have to understand, should be viewed through the eyes of the parties. How are they perceiving this? And they will pick up on the littlest things that you might not think about. So when you're thinking about impartial, it really is more than just what your relationships are, what disclosures you have to make. It revolves around the entire presentation of yourself in the role of the arbitrator. So we've also got this expectation that you are independent. That's where a lot of the conflict disclosures come up. You have to make sure that you don't have any, what's the word I'm looking for? I'm drawing a blank here. That you have no grounds in the outcome of the arbitration. You've got no connection. That means you're going to benefit from the arbitration. We want complete independence as best as possible. You need to be competent. Competency comes through in so many different ways in an arbitration. First and foremost, and we'll talk about this on the next slide, starts with the agreement of the parties with that arbitration clause. If the arbitration clause sets forth expectations for an arbitrator's service in terms of must have 5, 10, 15 years experience in X area, or must be familiar with Y area of the law, if you don't feel that you meet those expectations as set forth in the clause, you might not be competent to serve. So it has nothing to do with your ability to serve as an arbitrator. It's really talking about your ability to meet the expectations and obligations you have to the parties. And then finally, availability. This seems to be an odd one to show up in a code of ethics. But what we want to avoid is you accepting a case and the first thing you tell the parties is, I can't serve for 9 months. Or the first opening I have on my calendar is September of 2025, and maybe we can do a conference call then. It is possible as an arbitrator to become overbooked. You might become so popular that you are being asked to serve on numerous cases. What we tell AAA arbitrators all the time is that it is okay to say no. You might find yourself having to reject a case because you don't have the time to serve. When you accept the appointment, we want to make sure that you are able to give the parties the service that they have asked for. All right, Aman, so next slide. So these are some of the other obligations that Canon 1 sets forth. Number one, it's a continuing obligation. After you make your disclosures at the beginning of a case, you have an obligation to continue making disclosures through the life of the case. Your life doesn't get put on hold just because you're serving as an arbitrator. New things are going to keep coming up. So you have a responsibility to continue to review what's happening both in the case and also in your other practice areas to make sure that there aren't any new conflicts that might be coming up. We talked about your role as an arbitrator is governed by the parties' agreement. Again, if the parties' agreement requires something, maybe it's as simple as a locale of Fulton County, Georgia, or it goes to the qualifications that you might have. Might be something a little tricky. Maybe the parties have said that the hearing must be concluded within 150 days of the filing of the dispute. And then they mess around with the appointment process and you don't get appointed until day 140. You're still under that obligation to meet that 150-day deadline unless the parties agree to extend it. You also want to avoid delays. Nothing will upset parties more than you saying, you know, we had this hearing scheduled. I have an opportunity to take a vacation to Paris. I'm going to need to reschedule. Parties rescheduling hearings is one thing. Arbitrators should avoid doing that as much as possible. And then finally, see it through to the end. most arbitrations, because you manage them so expertly, are going to flow smoothly. They're going to go from start to finish as seamlessly as everybody needs them to. But every once in a while, you will get that case. And it will be that case that you have been serving on for 4, 5, 6 years. You are absolutely sick of that case. You want nothing more to do with it. But you have an investment in that case. The parties have an investment in you serving. We want you to see it through to the end to make sure that you complete your service on that matter. Okay, Iman? So then we get into Canon 2, and Canon 2 is really now starting to talk specifically about what needs to be disclosed, what conflicts or relationships that you need to be aware of. And it comes up in a lot of different areas. It might be personal or professional relationships. For those of you who have worked in the Atlanta area as an attorney for 20, 30, 40 years, chances are you know just about everybody. So think about how that's perceived from someone, say, coming in from Birmingham. Maybe they're coming in out of state and you're serving on a case. You're very familiar with the Atlanta attorneys. It's the first time you've ever met that Birmingham attorney. So not only do you have to make sure that your disclosures are up to date, but also, again, as we talked about earlier, keep in mind about how you're perceived, how you're interacting with people. Maybe it's a financial relationship. Maybe you own stock in Acme Corporation, and that is the company that's before you. Definitely at least a disclosure that needs to be made. Is it a current relationship? Is it something that's ongoing right now? Maybe it's in the past. Maybe you went to law school 25 years ago with one of the attorneys in the case. And then we'll talk about it more on the next slide, but that idea of a known relationship. What is your obligation in terms of how much research do you have to do to figure out if there's a conflict or not? And remember that relationships are not just defined by your individual relationship. Does your law firm have any ongoing cases or ongoing relationships with people? Maybe you're serving on a panel of 3 arbitrators and your relationship is with one of the co-arbitrators, not the attorney or the party. Maybe your spouse is a judge and your judge has a lot of relationships. So those are all factors that you need to be putting into the mix when you're talking about the idea or thinking about the idea of, do I have to disclose or not? Iman? So I mentioned reasonable effort, and I think this is one where a lot of arbitrators get tripped up. What is a reasonable effort? What do I have to do to find out, have I ever served on a case with this party before? Has my law firm ever been involved in a matter with one of the attorneys? So for those of you who work in law firms, you've already got a leg up. You've got access to the firm's conflict database. And at a minimum, you need to run some information through that database, see if anything pops up. If you serve on the AAA's roster, one of the services that we provide to our arbitrators is a prior service conflict report. Going back at this point, I think 10 years, we'll be able to tell you if you've ever served as a AAA arbitrator on a case involving that law firm, one of those lawyers, or one of those parties. If you find yourself working as an arbitrator independently, though, you don't have the resources of either the AAA or a firm behind you, this is something that you need to keep track of. Do not rely on your memory. I have finally hit the age that my memory is getting worse, and I would not want to rely on it. What's funny, though, is I'm also on the age, or at the age, that I might just be considering to apply to AAA's roster. So there's a disconnect right there. Do not rely on your memory. What you want to make sure is that you've got some sort of system to track the service that you have done as a neutral. It can be as simple as an Excel spreadsheet where you're writing down things like the case caption, the party names, the lawyer names, not necessarily every witness who appeared, but maybe at least keeping track of the expert witnesses. What was the outcome of the case? As you're making a disclosure about prior service, there's a big difference between saying something like, I served on a case for 5 years, had 40 days of hearing, issued an award, versus I was appointed to the case, then the parties went off and had settlement discussions, and they resolved the case 90 days after, and I never did anything. Although you had interaction on both of those cases, they're very different disclosures. And if your notes aren't kept in a certain way, you might not remember which case awarded, which case settled, which case was withdrawn by a party. So whether it's an Excel document, a Word doc, something that you are keeping track of, you want to make sure that you're recording as much information as you can. The wonderful thing about managing your own conflicts database as well is confidentiality doesn't matter. because this is just for you. It's your records. Now, when you turn around and make a disclosure on a future case, you might have to redact some information, or there might be some information you can't set forth because it is confidential. But at least maintaining your own records, more is always better, because something might jog a memory that you wouldn't have had otherwise. Iman? All right, so also still focused on Canon 2. We talked about it before. Remember that you have a continuing obligation to disclose. That goes through the date that either your service concludes because the case was settled, or the date you issue that award. It is not uncommon for you to serve on a case, you go through the hearing, maybe you've got a period of 30 days between the hearings closing and the award being issued, and you now have a disclosure to make. A lot of arbitrators think I don't have to make that disclosure because the hearings have already concluded. Well, you haven't issued the award yet, the case isn't over, you do still have to make that disclosure. And Aman can comment on this as well, but we often get phone calls from arbitrators, and the phone call starts with, John, I've got this issue. Do I need to disclose this? And my response is always the same. If you thought enough about this to pick up the phone and call me, then absolutely you need to make the disclosure. Maybe what I can help with is how to make the disclosure. But if you're going to call me and say, do I need to make the disclosure? My answer is always going to be yes. And remember as well, disclosures, relationships, these types of issues, maybe you're sitting there thinking, well, this isn't that important. No one's going to object to my service based on this disclosure, so I'm just not going to make it. Remember what I said earlier, it's not about you. It's about how you are perceived by the parties. What might seem to be an incredibly minor disclosure from your perspective could be huge from the party's perspective. And you might be very reluctant to make a disclosure because it's a major disclosure that you think is going to get you kicked off the case, and the parties don't care at all. They just rolled right off their back and they move forward with you serving. So again, put yourself in the party's position, and the party is going to want more information than less. So they're going to want you to make as many disclosures as you can. Come on. All right, so we've got some cases where arbitrators might operate in a very strange place. There are still some arbitration clauses out there that allow for party-appointed arbitrators who are non-neutral. They're essentially serving as advocates for the arbitrator, just as a member of the arbitration panel. This used to be much more common prior to 2003. This was something we saw on a fairly regular basis, especially in the construction industry. In 2003, the Code of Ethics for Arbitrators was updated, and we essentially flipped this on its head. It used to be that if you weren't sure if you were serving in a neutral or non-neutral manner, you could pretty much assume that you were non-neutral if you were appointed by a single party. In 2003, we changed that. So the assumption now is if you were appointed directly by a single party, you are assumed to be non-neutral. However, it is something that you need to verify as soon as possible. If there is any question about whether or not you are serving in a neutral or non-neutral role, you need to clear that up. If you're serving on a AAA case, we will tell you at the time you're appointed what the expectation is. If you're doing something ad hoc or with a different arbitration institution and they don't answer that question, definitely some information that you want to find out as quickly as you can. Iman? So Canon 9 covers non-neutral arbitrators, or I'm sorry, arbitrators who have been appointed by a single party. If you are neutral, even if you are appointed by a single party, you must comply with Canons 1 through 8 of the Code of Ethics. Being appointed by a single party means that you are able to talk with that party about maybe qualifications for the third arbitrator. You can have conversations with the party prior to your appointment about what their expectations are for your service. But once you're appointed, you are neutral, and you must refrain from having ex parte communication with those parties. So you must comply with these canons. Iman?
All right, I think before we get into, oh, no, we have one more. Sorry, John.
No, that's okay. So this is just the AAA rule that's sort of reinforcing the idea of Canon 9 in the Code of Ethics. You can be appointed by a single party. That doesn't mean that you are neutral. Again, the expectation is always that you are non-neutral unless someone has specifically told you that you are acting in a non-neutral capacity.
All right. So we're going to talk a little bit more about other grounds, other ways an arbitrator may actually exceed their powers, which would be an issue that creates a conflict that may have an award overturned. You know, we talk a lot, John, about in training with our arbitrators, if you're going to put out an award, make sure that you've protected the award. And one of the ways that you start doing that is by following those canons and code of ethics that John has discussed, but also continuing your appropriate and proper conduct throughout the case. So we're going to skip ahead just a little bit. I had a few cases that we were going to go over, but we'll go over them in just a little bit after we talk more about actual issues that could create issues that could be created by the neutral that would have an award overturned. So John talked a little bit about relationships. So if you are an arbitrator or a neutral, you could be a mediator as well that has a business relationship with a party. Meaning, let's say, I like to give examples. So let's say you are a neutral, you are working with business X and you happen, or not working with, but one of the parties is business X and you have a stock with that business and you do not disclose this stock. That is a business relationship with a party that is ongoing and also has potentially a monetary advantage if you rule in a particular way on a case. So that is something you want to disclose. Now, if you accept a referral from a law firm and you are a non-neutral co-arbitrator, that is something you want to discuss as well, because again, you could have a monetary and continuing relationship with this particular firm. Now, if you are on a case, a lot of our arbitrators are active filers, they are active litigators as well. So if they have a case that comes up, in which case, let's say an expert witness appears and that expert witness is against your particular interests or against you acting as a neutral, that is something you want to disclose as well. Now, if another attorney in your firm represents a parent company of one of the parties, that is also something that you want to disclose. If you are getting really any kind of hourly rate, your firm is getting hourly rate from one of the parties, that is something you want to confirm. A lot of times you don't know what the parent company is. And John had mentioned that you want to make a reasonable effort to make disclosures. That is something you do want to look into. So if that's not something that you already have as part of your search, you do want to go ahead and do that. Now, in construction and healthcare, a lot of the times we have repeat filers, we have repeat respondents, and that's just kind of the nature of what it is. There are only so many healthcare companies, and the construction industry is only so large. I know it is a large industry, but there are only so many players in the industry as well. So if you've had an arbitration, let's say 2 years ago, and you're seeing the same respondent or you're seeing the same claimant again, that is something that you want to disclose. Now, it may not be an issue where you disclose and they say, well, we just had a horrific time, we're going to remove this person. Or it may not be a situation that says, well, you know, it's a different case, different situation, different party, maybe even, but same party rep. You still want to disclose that, especially if you had an award. Sometimes we get disclosures that say, well, you know, we didn't really make it to the award. We kind of ended after the preliminary hearing. That's okay to disclose. It kind of gives you an idea of how far you went into the information for that party or that party rep as well. And then, John, we see this a lot where we have a body at the AAA called the Administrative Review Council. And when they do these reviews and they say, well, I've had 5 cases with this party rep or 5 cases with this party, but it's been so many X years, you know, how do we kind of look at that determination to see, you know, is this person going to continue to be on the case? Or is this enough of a disclosure to say, okay, well, we're going to remove this person from the case?
We've got at the AAA, we've got a fairly, at least on its face, straightforward test that we apply to any challenge that we receive. We're looking to see, is the conflict direct or indirect? We want to know, is it recent? Is it continuing? And is it substantial? So some of those are easy to check. If you previously served as an arbitrator on a case involving a party or a law firm, that's a direct conflict. I mentioned earlier, maybe you've got a spouse who's a judge. That would be an indirect conflict. Continuing, again, that's an easy one to check the box. It's ongoing or it isn't. Recent is where things start to get a little fuzzy. Depending on the circumstances of the case, maybe something that occurred 6 months ago is recent, but on a different case, maybe 6 months ago wasn't. It just depends on what type of service you provided, what your involvement in the other case was. There are some states as well that have statutes that limit an obligation to disclose. They might cap the disclosure requirement at, say, 5 years. It's important to understand that AAA's rules do not have that cap, and neither does the Code of Ethics. We expect you to disclose any relationship that you're aware of, even if there is a statute that would limit that on, say, court-appointed arbitrations. And then finally, we've got this fourth category of substantial, and that's where things can get a little gray. What happened on one case might be substantial. What happened on a different case might not be. We're really just looking at a totality of the circumstances surrounding what the relationship is, how long ago was it, what your prior service might have been, that sort of thing.
And what's interesting is a lot of people don't realize, when we're having these conversations about disclosures and award vacatures and how it can affect the award and kind of maybe the perception of bias, is I think a lot of neutrals feel like, well, is it all on me? What if I do forget something? What if I didn't have something in my notes? These same, at least at the AAA, and I'm sure it's the same all the way around, but these same obligations fall on the parties as well. So when you have a party representative that's appeared before you and, it's an arbitration, maybe you don't remember there's an issue with the notes and you've lost those notes, and maybe they were co-counsel or they were counsel on the case, but they weren't really involved. They just kind of appeared for the hearing. If that's not something that you kept, the parties have the same obligation to make those disclosures. So if you disclose, yes, I had an arbitration with X and X, or, I don't recall having an arbitration, I don't have it in my notes. The parties have a time with us as well at the AAA to say, you know what, I actually do have these notes, and I'm telling you that I had an arbitration, I appeared before this arbitrator. And we take that into consideration as well. And when the issue of vacature comes up, you may think, well, let's say I didn't have those notes. I didn't have those notes. I didn't have the memory. I didn't recall that information. I didn't remember the person as I looked at them, in the face sitting in the room. How does that come up later if the party did know and they're asking for vacature? Well, there's a pretty strong threshold in reviewing award vacature. And one of them is, if you as a party knew that the arbitrator had a particular disclosure, or maybe they didn't remember, but you knew about it and you sat on it, and the award just didn't go your way, that's not a way to get an award vacated. If you knew about it and you were sitting on it, you're going to have a pretty hard time saying, okay, well, yeah, the award didn't go the way that I wanted. And by the way, it didn't go this way because I knew that this relationship existed, or this disclosure existed, or this conflict existed. And I just sat on it to see how it was going to go before I decided, it's not going to go, but it's not going to go the way that I want. So I want it overturned.
Yeah, and Aman, if I could,
Yeah.
I think a lot of arbitrators fear making disclosures because they're afraid they might get removed from the case. The Administrative Review Council that Iman mentioned, we've been tracking removal statistics for about the last 10 years or so, and we remove an arbitrator about 37% of the time based on a challenge that's presented. So I hope I throw that statistic out maybe just to put your minds at ease a little bit. So many arbitrators think I make a disclosure, I will get removed, and that's not the way it works. Once you make the disclosure, first the party actually has to make a challenge, which doesn't always happen. And then even once there's a challenge, the AAA, at least under our framework, will make that final decision.
Yep. Fantastic. So let's see. So exceeding your powers. A lot of people wonder, where does my power come as a neutral? Where does the power come to the neutral when we have them on a case? And a lot of the times, I would say the majority of the time, it's coming from your clause. So when we get a case at the AAA, we're looking for a couple of things. One, of course, that you have a claim and you're letting us know what the claim is. We have a simple 1 to 2 page demand form that gets filled out. But the main thing that we're looking for is the arbitration clause itself. So in the arbitration clause, when we get them, it says the AAA AAA will have, or the AAA's rule will govern the arbitration proceeding, and that's really enough for us to move forward. Sometimes they say the AAA specifically will administer as well. That's fantastic. But then the arbitrator is getting power from there as well. If the arbitration exists in the clause and you're coming through the AAA and using the AAA arbitrator, that is where the power is coming from. But we talk a lot about, if there's a claim and the claim is asking for particular things, that is what the arbitrator, the neutral, should be focusing on. If something comes up during the hearing, it's not part of the claim, you shouldn't actually be ruling on it, or if you go out and do your own research and say, well, actually, this is part of it as well. If the parties didn't ask for it, you shouldn't be making an award on it. So you don't want to exceed your powers. Let's say, a party files a case and they say, well, I'm looking for, what's a good example? I'm looking to be compensated for X service that I did. And the arbitrator is focusing on the X service, and that is what the claim is. But if the arbitrator does, their own review or has a different understanding of the law, or the parties bring up something else that is maybe in the agreement but not part of the arbitration clause or part of what the claim is, they can't just go outside of that. You have to have a very narrowed focus on what the actual allegations are and what was actually submitted in the claim and in the pleadings. You shouldn't go outside of that. And a lot of times an issue comes up there where it's an issue of, let's say, attorney's fees or interests on a particular damage. You definitely want to look at the law that your case is under and make sure that you are looking at the correct thing so you're not exceeding your power that way as well. John, do you have any notes about exceeding your power?
No, just to reiterate what you said, everything flows from the arbitration clause. And what we often tell arbitrators is the first thing you should look at when you get a case is the arbitration clause, so you understand what the scope of your authority is. Are there any limitations? And really the last thing you should do before you issue that award is look back at the arbitration clause, compare that to your award, make sure that you haven't awarded anything that exceeds your powers.
Exactly. And so what's really great also is, we have tools, and I'm sure a lot of other people do as well. So I can only speak to the AAA because that's where I work, but I'm sure other people have these tools. Is when you are actually going through the award and you are putting it together, we ask you to complete an award checklist. So that's actually a great reminder that we use to say, hey, go back to the award, go back to the claim, go back to the contract itself, and make sure that what you are doing is actually in line with what was requested and not outside of that. If you do exceed your power, you do want to take into consideration what that's going to look like. Is your entire award going to be overturned? Is part of it going to be overturned? From what I've read, it's probably going to be the entire award. So stick to the facts, stick to what's in the claim, and make sure that that's what you are doing your award over. Now, there's a few other ways that you can exceed your power, and I apologize, this says his, I realize that her can also be an arbitrator. So there's a few other ways that you can actually exceed your powers. And this is the first point that we have here is actually a great one. A lot of the times we get a full provision that is an ADR provision. So it's not just arbitration, but it mentions something about mediation as well. And there is an issue that comes up of mediation needing to be done before the arbitration takes place. Now, when you have a case administrator on a case, they're having an initial administrative call with the parties asking, well, even per our rules, because your claim is X amount, we're going to ask you, have you done mediation or not? And the parties are actually able to opt out of that. But let's say you get a clause that says, well, mediation is a condition precedent. You have to do it before you get to arbitration, and the parties will tell us, well, we tried to reach out, we had a conversation, it was informal mediation, we tried to do this and that. And then one party will say, no, we didn't, we did not do that. We didn't go formally anywhere. I don't recall getting any kind of information. I don't consider our conversations to try to settle this matter as a mediation effort. The AAA will not make a ruling on that. Is that correct, John?
Yes, that's correct.
Yeah. That's correct. Yeah. So what we will do is we will say, well, this is an issue that is left to the arbitrator, the arbitrators of your case. So what we'll do is kind of tee up the issue for the arbitrator right from the beginning. So it's probably going to be the first issue here. It's almost like a preliminary hearing, but you're not really going to get to the rest of the deadlines. You're going to be talking about whether or not conditions were met. So let's say it is very clear in your contract that you are dealing with that mediation had to have been done before arbitration. And even then, let's say It says you have to have had an impasse. You have to have some kind of order from the mediator. You have to have some kind of note from the mediator, some kind of agreement. If that does not exist and you go ahead and move forward with arbitration, that could be an issue. So you may be exceeding your powers there as well. Now, the parties may say, well, can we just run the mediation concurrently with the arbitration? If they agree to that, that's not an issue. If they agree to waive the condition, that's not an issue as well. But you want to make sure that you actually have that agreement. We talked a little bit about costs and fees, so you do want to make sure that you are going with the laws of your state and your region, as well as what is in the contract as well. I don't really see a lot of contracts that address attorneys' fees. John, do you see a lot of them? At least as it pertains to mediation arbitration?
A fair number. I wouldn't say it's a majority, but it's a significant percentage.
Right. So if for some reason as a neutral you have a question about it, try to address it up front, address it at the preliminary hearing. And if you forget to, that's not an issue. You know, there are other times you can ask about it as well. Don't wait until maybe after the hearing to ask, because there may be a dispute there, you know, especially if the party feels like, well, this case went one way or the other for me. And, you know, make sure that you are staying within the arbitration agreement, really. You know, it's not an issue if the parties have an agreement. A lot of the times an arbitrator asks, well, you know, it's possible that the attorneys have an agreement, but the parties that enter the contract themselves don't have that agreement. If you are concerned about that, I've seen a lot of neutrals create a document that says, you know, this is what we discussed during a call or during a Zoom, and this is outside of what's in the clause itself, or maybe a little bit outside of what the claims are what the claims initially were. And they will have not only the attorneys sign it, but the actual parties themselves sign it as well. So maybe business X and business Y, and that can kind of go into play as well. So that way you have a written agreement. It's not something that you just discuss on the phone. And I think that's a great way, you know, to say, well, it's not just the attorneys that came into this litigation or arbitration or mediation that signed it. It was actually the parties themselves that came into the contract. All right, so we talked a little bit about exceeding your powers in terms of going outside of the contract. So there is also, you know, kind of the manner at which you deal with the agreement. So we have a lot of contracts that we receive that say, well, you're going to have X and X amount of depositions, X and X amount of discovery, or there's going to be no discovery or limited discovery. And the parties haven't said anything otherwise in terms of what that should look like. And you decide as a neutral, well, I need this, this, and this in order to make some kind of ruling or do some kind of review. So that's something you want to look at as well. Don't just go straight outside of their agreement and say, well, I need this. Make sure you talk to them about it first and get the agreement. Now, we see a lot of issues with I would say maybe more enjoinder issues if someone is a signatory or non-signatory to a particular contract, whether or not they still had the authority to sign that contract as well. So that's something you want to look into very diligently before you make a decision as to whether or not a party is included in the final award or the arbitration proceedings themselves. So that's a little bit, I mean, everyone is able to read the slides as well. So I don't want to just kind of reiterate what's on there, but that's a little bit about exceeding powers and kind of the rules that you need to follow and things that you need to disclose. But before we talk about cases, I do want to see if there's any questions. And we're okay with people just speaking up or saying something as well if they want to. No one, there's no negative points if someone decides to speak up. Let's see, I don't see any questions coming through. And just John, before we talk about cases, is there anything that you feel like we haven't discussed or missed about making sure that you make the proper disclosures and making sure that you don't exceed power so that your award is overturned?
No, I think we've touched on the high points, which is make sure you've got a process in place for tracking relationships or work that you've done so that 5 years from now, when you're trying to make disclosures, you have that resource. You know, Aman's talked a lot about the arbitration clause and how it's very easy to exceed your powers if you skip around a provision. What we have found is that there are two types of arbitration clauses. There's a very generic clause, which calls for AAA jams, something like that. Or there's the person who had a bad experience in arbitration And so they wrote a clause specifically to avoid the bad experience they had and have overcomplicated the entire process. You don't see those very often, and it's very easy to just fall into the idea that every arbitration is the same. Just we can't reiterate enough the requirement to make sure you've reviewed that arbitration clause, because if it is one of those strange clauses, you want to make sure that you are following those provisions as closely as you can.
And for those of you who are thinking, well, you know, how do I know that my clause is okay? Should I go back and review it? You're welcome to send it to your regional vice president as well. They can take a look at it if they see something very alarming or anything that could be reworded maybe to be a little bit more clear. You know, your regional vice president will look at that and talk to you about it as well. But some people have said, well, I have a really generic one and it's caused some issues in the past. You know, maybe it just says we are going to the AAA, we are using these rules, boom, that's it. If you want to create a clause that maybe has a little bit more information on it, something that makes the process a little bit more clear, something that the arbitrator can follow as well, so it's very clear as to how the process is going to work when you file or you have a case maybe that's filed against you, is we have a free tool on our website. It's called Clause Builder, and it's clausebuilder.org. Clausebuilder.com is something else. If you see it, I mean, I've seen it, it's nothing bad, just it's not what our tool is. So if you go to clausebuilder.org, you'll actually get a tool that takes you step by step through the process of creating a clause for your contract. And it actually includes quite a bit of information on how the arbitrator selection will work. So we talked a little bit about party appointed neutral. So if that's a process that you want to do, there's actually a question as you go through the tool itself that says, do you want to do this? How's it going to work? And it gets down even to the fine points of saying, okay, well, how many arbitrators are you going to have? Is it going to depend on the threshold of your case? So I've seen some people that say, well, we'll have one arbitrator if the case is under $1 million. We'll have 3 arbitrators if it's over $1 million. So you can get down to that. You can even put qualifications. So John had talked about, you know, in the clause about being competent and you know, available and knowledgeable of the issue itself. So as a filer, as someone who is writing a contract as well, if you put in a clause that says, you know, we need an arbitrator that has at least 15 years of experience, and let's say specifically they need to have dealt with, let's say, I don't know, I'm in my construction mindset, so engineering of bridges. So if that's something you want to include, and that's something that you want to make sure that we take into consideration when we're putting the proper arbitrator in line with you, you are able to do that as well. And as far as the party appointment process goes, you know, if your clause doesn't say that they're going to be neutral, our assumption is that they will be neutral. So if you're going to build a clause that says that the party appointed arbitrators are non-neutral, but they're still going to obviously follow these rules and the code of ethics as well, make that very clear so that we know that we're putting kind of the right process in place for you as well. You can go down to even something that says, well, claimant will, at the time of filing, provide their party appointed arbitrator's name. Respondent will have 30 days after that or 2 weeks after that to choose theirs, and they will get together and choose a chair and what that chair process looks like. I really do encourage everyone to look at that tool and have those conversations. If you are not the drafter themselves, have a conversation with the person who's doing the drafting so that we have very clear lines as to how the arbitration works and what the parameters are of the arbitrator as well. And John, is there anything else in the tool that you would recommend that people look at?
Not specifically, honestly, just to reiterate that it is a great tool. And even if you're not in the market for an arbitration clause right now, it can be an interesting tool just to navigate so that you can become familiar with it.
All right, great. So I'm actually going to stop my share screen. I'm going to talk about a case that I realize is actually not in the slides, but it's a fantastic slide. So I do want to ask Scott and Lane, are the slides going out to everyone that's logged in today?
Yes, they were emailed yesterday as well as again this morning.
Okay, great. So I do highly encourage everyone to look at those slides. There's quite a bit of information about cases that have come out that are relatively recent that talk specifically about arbitrators not disclosing certain items, and then arbitrators maybe exceeding their powers and how their awards were overturned. What was disclosed, what was not disclosed, how was the authority exceeded? So I actually want to give an example of a case that I did research on not that long ago. It's a case that came out of Texas. You're welcome to look at it. And it's actually a divorce case. And so in this particular divorce, the husband and the wife went to arbitration. And what they did is they had the arbitration kind of go very much in one way. And the arbitrator in that particular case didn't really make a lot of disclosures. They just said, yeah, I'm familiar with the attorneys that are involved in the case, and that was it. And you know, the arbitrator themselves was a former judge, and so that disclosure itself is not unusual. A lot of judges will say, yes, I've seen these parties, they've come before me before in the court, you know, maybe the judges don't keep as much information in terms of like, this is the exact case that it was. A lot of our arbitrators won't give the case numbers and the case information, which is absolutely fine because that's confidential the majority of the time anyways. So this particular arbitration in a divorce went forward, and the award was given, and the wife had later found out that there was actually a relationship between the arbitrator and the husband's attorney and the husband's attorney's co-counsel that was not disclosed. So as she is figuring this out, she received information actually not only that the arbitrator knew personally the husband's attorney and husband's co-counsel. It actually came out that the arbitrator shared a home, like a vacation home with the husband's attorney co-counsel. They've been there at the same time. They I think there was something like they shared the same spittoon, which I think is just kind of gross. I don't know why someone would do that in general, but you know, the arbitrator and her husband's attorney's co-counsel were like that. So they actually had a pretty substantial relationship, and it just wasn't disclosed. And so that actually went before the court, and the court said, well, you failed to disclose. Not only did you fail to disclose, the attorney failed to disclose, and the wife didn't have the benefit. So it creates this bias of, well, maybe that's why the arbitrator ruled in that direction. You know, I didn't know that these relationships existed, and they went in that direction. So they actually had the award fully overturned. They had actually, I believe the wife received additional compensation as well through as damages, and then she received her money back for that as well. So it is very important to realize that it is, you know, you've got to disclose these relationships. There is one word that has come up, you know, when we review disclosures, which is the word friend. And I was just on a call with John not that long ago, and I said, oh, I wish this person had not used that word. And we just see it so often. So, you know, the relationship that I'm talking about in the case that came out of Texas for the divorce, if you're sharing a home and you are sharing, you know, whatever your spit cup, whatever it is, you know, you probably are friends or friendly. And that can create an issue of bias. But we have this question of, well, what if I'm friends with someone on social media? Am I actually their friend? Do I spend time with them outside of work? Let's just say we're involved with the same bar association. We're all part of the Georgia Bar Association. Does that make us friends? So I want you to be very careful about what that word looks like. And John, why don't you talk to us a little bit about kind of what the perception of that word creates?
Well, and remember what we've talked about. It's not your perception of the word friend. It's how the user is perceiving the word friend. And as soon as you say friend, they are picturing some type of personal relationship. And the problem is that they often don't have enough information. So they're filling in the blanks on their own. And if you've said the word friend, then that's going to color how they're filling in those blanks. So always, you know, we would encourage you to think carefully about, is it a friend or is it an acquaintance? Is it a professional acquaintance? Do you have a professional friendship, I suppose, with someone? You know, just remember that whatever word you throw out there, you lose control over because it's now being perceived by the party.
Right. And there is this question of, you know, I don't usually recommend that you make a lot of friends on Facebook. And we've had some issues where people have said, well, they're friends on Facebook, and that word is just used on that particular app, right? Friend. I usually say, well, I have a lot of quote unquote friends on Facebook as well. I'm not really friends with them. I just happen to know them and I'm connected with them. And a lot of our arbitrators have asked, how do we address then connections on social media, whether it's Facebook and LinkedIn? Some of our arbitrators do actually provide now a general statement at the end of their disclosure saying, I am a part of Twitter, I am a part of LinkedIn, I'm a part of Facebook. I'm sorry, not Twitter, it's called X now. And then any other social media platforms that they have as well. And they say, you know, I am connected with quite a few people. Maybe I didn't go through LinkedIn, or I see that I'm connected with them on LinkedIn, but it's just a professional website. It's not necessarily that we are connected otherwise outside of any professional setting. And a lot of people will say also, well, then how do I address that? Then I am part of the Georgia Bar Association. I'm part of the Texas Bar Association, Dallas Bar Association, Atlanta Bar Association. How do I address that? You know, is it something that's going to count against me that I'm active there? And we do encourage our neutrals and our filers to continue to stay active in these bar associations, because that is how you're going to meet a lot of your colleagues, right? That's how you're going to build professional relationships. And I wouldn't say that being part of an association with a bunch of hundreds of other people is going to be a disqualifying disclosure. But if you know that you are actually active in it, maybe you're the president or you're part of a group, and maybe opposing counsel or you know, the other opposing counsel are part of that association as well, disclose that. But if you're just generally part of a professional association, I wouldn't take that as a disqualifying disclosure of any way. And we're right at the 10-minute mark. So I want to make sure that Scott and Lane have a chance to wrap up and then we address any questions as well.
Well, I guess I'll come back on in a minute. I do want folks to ask any questions that they have of the two of you while we still have time. Iman, you had previously in your slides a number of cases that you referenced. I know that it will be provided in the materials, but I know I got a lot of response about your program dealing with maybe a quick summary of some of those cases. What are the key issues that you're seeing as the basis for vacating arbitration awards, other than the disclosure issues that you've talked about? Any sort of top 5 concerns that arbitrators have based upon those cases that they should be worried about that subject them and their awards to vacatur?
Sure. So I think primarily what we'll see is disclosure. One case I actually took out of those slides was going to be the Monster Energy. And so I'll talk about it in more of a generic sense, which is if you are going to be a part of an arbitral institution and you do see repeat filers and you maybe have a relationship with one of those filers, or maybe the respondent in a particular way, but you are also receiving like a stock option, or you're receiving part of the profit share of that company, that is something you want to disclose. I had mentioned before, you know, if you have stock with a particular company, you do want to disclose it, whether it's the parent company, the company directly, or if it's a derivative of that company that's like maybe a smaller branch out of that, that is something you want to disclose. Business associations, or you know, anything that maybe you receive monetary funds from, you want to disclose that. You don't want to create a situation in which, and this is maybe on another one of those cases that I put in there, is you don't want to create a situation in which you create a view or a perception that says, well, I ruled in the favor of this because then my stocks will go up and I want to make sure that I get a share of that, right? You want to disclose that. And as John had said, if it at all pops into your mind, you should put it out there, right? If it pops into your mind, the default should be, I should disclose this. And if you have a question, call us and talk to us about it. So the main thing is going to be disclosures. Secondarily, I see the exceeding of powers. And then maybe not as often as what we see is just a complete disregard of the law itself. John, do we see that quite a bit, even in things that we review in ARC?
No, manifest disregard used to be the hot attempt to vacate an award, but it's really fallen out of favor recently. I think there are still some states that have manifest disregard as part of their statutes, but it's not. It's been disfavored by the FAA under the FAA.
Right.
So let me ask the other question that's come in anticipation of this program, dealing with that same issue about manifest disregard in the award of attorney's fees. We know that there's some stress points about the issue of prevailing party as referenced maybe in the contract, and the arbitrator having discretion based upon the claims and counterclaims that are presented and how they award based upon those claims and counterclaims to make a determination that maybe $1 awarded is not a prevailing party. Can you talk about that? Because I know there's a lot of anxiety with regard to the awarding of attorney's fees based upon the contractual assumption that prevailing party may get attorney's fees.
I always say default and look at their law of where you are, but I don't know, John, if you have some more information on that.
So I think I have a similar response. there are so many slight differences between statutes depending on what state you're in or what law is applying. If there is a prevailing party clause that is not clear or that gives the arbitrator that discretion, they definitely would want to do a little bit of research.
Yeah, John, so I'm going to add to that. If you're one of those arbitrators that believes also that I shouldn't be doing a lot of outside research, if you're concerned about billing time for that as well, you can always ask the parties to brief that, and they can get you kind of a concise summary of what you should be looking at to make that determination.
I think that was one of the concerns is outside the hearing and other study doing independent research on some of these questions as compared to having the parties brief those questions. And I'm here, so I'm sounding that your recommendation would be it'd be permissible to the parties brief it based upon the arbitrator's request.
Right. So, and I'll give kind of this kind of general example. Sometimes we get an arbitration clause that says the locale of the hearing is Atlanta. And so then the parties default and say, well, okay, well, then the arbitrator should be from the Atlanta area. So they're from Georgia. So that's their understanding. But the case law or whatever law, that prevails for the clause is Delaware, or it's Massachusetts, or it's some other state. If you as an arbitrator within the locale of where the hearing is, if you're not familiar with the law there, I would always encourage the parties to go ahead and brief that information, because they're going to give you the information that you need to make that determination versus maybe you receiving extra information doing independent research. And it also saves quite a bit of your time as well. We talk a lot about arbitration being a cost-effective and a cost-efficient process. One way to make it cost-efficient, cost-effective is to get the briefing directly from the parties themselves.
Okay, and then since we have time for one more question, this may go to the Vacatur question about the original arbitrability jurisdictionally of a dispute coming up later, that the arbitrator decides that they have jurisdiction to render the decision based upon the determination that the matter should be arbitrated. Do you typically see filings for vacating the award based upon the fact the arbitrator didn't have jurisdiction at all under that? Is it too late, or thoughts on that?
I've only seen one, and it went in the favor of the arbitrator did have the jurisdiction. John, have you seen anything else?
No, that usually gets wrapped up under the exceeding their powers argument. As long as the arbitrator has made a good faith determination that they have jurisdiction, most courts are willing to abide by that.
And I will say also sometimes, when we're having these initial administrative calls with the parties, when we're talking about what's going on in the case, when someone addresses the issue there or they bring it up there before we even have an arbitrator on the case, sometimes we get a concerned party that says, well, of course the arbitrator is going to say that they have jurisdiction because they want to keep the case and they want to move forward. I wouldn't say that that's the case. I have had many arbitrators that have said, I do not have jurisdiction, this case is going to close. So if you are a party or a filer that has that concern, I wouldn't feel like the arbitrator, of course, is going to say, of course I have jurisdiction, we're going to move forward. I have seen it go the other way as well.
And then just lastly, since you're both AAA folks, and I know you're doing a lot of education and forums to provide advancement for both arbitrators, mediators, and advocates, anything coming up for you guys for the AAA for programming for us in the next few months that you want to advertise now?
Good question. So we have a AAA, our annual AAA construction conference is coming up. It's going to be March 21st. It's going to be at the Biltmore in Coral Gables. If you are a construction arbitrator, construction filer, construction attorney, I highly recommend that you come to this. It's a lot of fun, and I don't say that just because I'm going over the ethics portion. I will make it as fun as I can at the end, but the rest of the topics are fun as well. So I do recommend that you come there. I'm not sure about on the commercial side though. John, do we have anything coming up for the commercial side?
Nothing locally in the next few months, no.
All right, well, if you are arbitrators though, and you are familiar with our roundtables, I highly recommend that you continue to come to those. Those of you who are interested in being arbitrators, if you want to figure out what those qualifications are, we can talk to you about that as well. John is your fantastic contact regionally for the commercial side of the panel, and then I am your contact for the construction side as well.
Terrific. Well, on behalf of the State Bar, really want to thank both of you for taking the time to present to our group today. Very helpful information, things for us to really take back and include in our practices. Thank everyone for joining today, taking time to your lunch for a little lunch and learn, and to participate and support the dispute resolution section of the State Bar. Everybody have a very happy, healthy holiday, and we'll see you all in January. Thanks so much.
Thank you.
Thank you.
Ladies and gentlemen, this does conclude today's meeting. Thank you so much for joining and have a great afternoon.